It's quite an exciting webinar, to be honest. We've done a lot of research and we've looked. I mean, AI is new, but at the same time not so new. So we thought let's grab some of expertise of people who are really into that field. So we will have 4 people presenting something today. Each of them have a bit of an expertise from a different field. And the whole idea is that we have the floor for 20 minutes for each of them to share their experience and what they've discovered so far. And of course, it's not going to be just related to criminal law, because of course now as practitioners, it can be related to different ways of work. So this is useful for your daily tasks in general. And then of course we'll finish with the floor with questions. So please feel free to ask the questions. To just make it easier, maybe that would be great if you can put your questions in the chat, so we can then go through them with a certain order and then direct them to certain some of the experts or in general, if that's all right with you. So to start, Thomas, maybe you would like to start by explaining, in very general, although it's difficult to give a general definition of AI, like we discussed the other day, just an idea of what AI is, what it means, in a very general manner, so to say.
Okay. Hello, everybody. Maybe I'll start introducing myself. My name is Tomasz Durek. I'm a researcher. I'm a computer scientist. I work in the University of Amsterdam, but I'm also in the Informatics Institute, but I'm also associate fellow of the TMC Asser Institute in The Hague, and as well as assistant professor in the Maria Curie-Skłodowska University in Lublin, in Poland. My main interest is in the intersection of artificial intelligence and law. That's why I'm here, the question about artificial intelligence is a problematic one, because there's a number of definitions of AI, the very misleading thing in the current discussion of this topic is that is treating AI as a kind of entity, something which one type of AI which exists, something like, let's take AI and do something with this. And this is very misleading, especially for the people who are not very much into technical details, because AI in fact is a set of approaches, technical approaches to solve the problems for which we use our intelligence. To solve these problems, we use our intelligence. For example, the object recognition, finding the best solution in the set of possibilities, to voice recognition, to finding routes somewhere in the complex environment, and so on and so forth. And this is in translation of texts, modifying of texts, and whatever. And there's nothing like a single approach, single technology which is used as an AI. In practice, AI is a set of tools which we can divide into 2 main groups. The first group was traditionally something what was called AI, and this is sometimes called GoFi, good old-fashioned AI. Which is such a approach. Is a so-called knowledge-based approach. It's an approach in which we are trying to translate our knowledge into the computational formulas, and we represent strictly our knowledge in the computer, something with the use of logic, with the use of extended logical tools, some mathematical models, and so on and so forth. And in this approach, the good thing is that this approach is clear and, let's say, understandable for humans, more or less. The bad thing is that we can only translate the knowledge which we know. We cannot translate something which we are doing unconsciously. We cannot translate something which we don't know how we do it. And the second approach to AI is recently extremely popular. Of course, is a machine learning based. It's an approach in which it's called sometimes data-driven AI, an approach in which we are using learning mechanisms, mathematical learning mechanisms, in order to train the computer to perform some tasks. For example, object recognition, right? Differentiating cat from dog or something like that, and differentiating weapon from a toy on a picture, or whatever. So this is something. This is the second approach to AI, and there are these knowledge-based and data-based approaches. There are two different approaches which are in the whole history of AI, where it was a kind of competition between these two. Sometimes the knowledge-based systems were much more popular in practice. Sometimes data-driven approaches were popular in practice. Recently, of course, it's the data-driven and all the mechanisms used by ChatGPT, all the large language models, all the object recognition mechanisms. They are built on the basis of data-driven approach. Data-driven approach has a very significant drawback, is that it's not fully explainable. And the problem is that there is a how to describe it. There's in the discussion of explainability of data-driven models, is that usually people don't know what they want, because there are, of course, possibilities showing which input influence the most the output for the data-driven approach. So I say which parts of the picture most significantly influence the recognition that on this picture is a cat, for example. It is quite relatively simple to be prepared. The problem is that we as humans, for us, the explainability of such a mechanism is much more something which something which is much more complex, because we as humans, we can explain also our motives, our goals, and our assumptions which we have when we explain something. In machine we cannot do that, because machine doesn't have anything like motives or goals or aims or whatever. So this is very difficult to be discovered in such a mechanism. Why such a mechanism gave such a decision or recognized that there's a cat on this picture, not a dog. And this is one of the most difficult and most important problem of a data-driven AI. Of course, there's a coming to conclusion, and not to bore you too much. Of course, there's a number of approaches in which people try to merge these two. I mean, data and knowledge-driven mechanisms. But still, it's very difficult, and it's still not a solved problem in the research in general. And yeah, and I think it's very briefly the very brief definition of AI, and with some basic assumptions which are behind it. So thank you for now.
Thank you very much, Thomas. Yeah, indeed, it is. So that's true that sometimes we have the tendency to forget that there are different types, and some of them can be a lot easier to understand how the decision was made, and others less. And so maybe I'm sure there will be a lot of other questions we'll raise about that specific difference later. So if everybody is okay, let's maybe then look with Laura Caroli and see what she has to say on her side of AI.
Hi, Helen. Thank you for having me. Just maybe a quick introduction before I pass to the presentation itself. So my name is Laura Caroli. I am the former parliamentary assistant to Brando Benifei, who was one of the two co-rapporteurs of the AI Act, so for the Parliament, and I oversaw the negotiation of the AI Act since its very beginning, since the Parliament started its work. So it's been for us 2 years of full work on this until we found a final version of the text. Now I have prepared a quick presentation so that we don't get lost in the text. Let me share it with you. Yeah. Sorry, my computer is a bit slow. Okay, so I would like to give you a few elements that might be relevant for your work, given that you are practitioners who work with the International Criminal Court. So one first thing to say about the AI Act and how it could affect your work is about the scope of the AI Act, meaning that in Article 2, apart from the very usual notion that a provider who markets an AI system in the Union then is in the scope when the system is a high-risk AI system, there is also indications whereby also deployers may fall into the scope of the AI Act. For example, if they are established in the Union, when so practitioners established in the Union, and even if they are not established within the Union, as you see in the first point, if the output is used in the Union, if the output of the AI system, and also affected persons that are located in the Union, so not only EU citizens, but also I don't know, immigrants that reside, that are present in the Union, fall into the scope of this regulation as far as their fundamental rights are affected. So bear this in mind when you use AI tools in your everyday work. Very important remark, GDPR still applies even with the AI Act. So whatever you know about GDPR, all the principles, transparency, data minimization, retention periods, they still apply. So this is very important. Of course, they operate in conjunction, these two pieces of legislation, and make things a bit complex to navigate, but it's important to understand that they have to coexist together at the same time. So this does not override the GDPR. Okay, so one further important thing to say is about the risk classification of AI systems, because of course AI systems that are used in the areas of justice, law enforcement, etc., we will see later, are high risk, but only when they fulfill, well, only if they don't fulfill the following conditions. Basically, because this is an exception that we had to make, because from a first reading of Annex 3, the use cases that were listed could make systems that are actually very simple tools, you know, to put data in alphabetical order, or to detect patterns, you know, just preparatory tasks that actually do not materially influence the outcome of the decision, or do not significantly affect fundamental rights and health and safety of people, then these systems should not per se be considered as high risk just because they belong in those areas and use cases. So we try to craft some conditions that you see, these 4 conditions that you see in this slide, that trigger the fact that even if they are, the system is in one of the use cases in Annex 3, if it fulfills one of these conditions, then it's not a high-risk use AI system. And this will actually be evident by the fact that the provider of these non-high risk AI systems will actually have to make an assessment as for the reasons why it fulfills one of these conditions, and it will have to register the AI system in a specific section of the EU database, which will be the section for non-high-risk AI systems. So if you are using one of these tools that you see are listed in that section of the database, then you know for sure you don't have to apply the AI Act because it's not a high-risk AI system. So this is very important to know, to have a first filter of how to classify an AI system. But with a caveat that you see at the end, if these systems, even if they do one of these 4 things, but they perform profiling, then they are high risk by default. If they are, of course, always, we are talking always Annex 3, and not all AI systems that perform profiling are high risk, but if they are already in Annex 3 and perform profiling, they are high risk. I know it's a bit complicated, so if you have questions, I will be happy to answer. For us, it was a conundrum for ourselves to negotiate this text, believe me. So let's move on. More concretely, so this is the area of justice, the systems relevant in the justice area in Annex 3. So AI systems intended to be used by a judicial authority or on their behalf, or to assist in researching and interpreting facts and the law, and in applying the law to a concrete set of facts, and also to be used in a similar way in alternative dispute resolution. So basically, we say, okay, you just use AI tools to research, your case. That should not, for some, be high risk. We even talked to some startups that told us, we don't consider ourselves high risk. But there is a but, because we thought, okay, if the result of this research then leads to a certain interpretation of the case, and therefore to a certain outcome, then yes, these systems are high risk, because they do have an impact on the outcome and on maybe a person, on the fundamental rights of a person in the future. So this is why these systems are considered high risk per Annex 3. Okay. This is the area of law enforcement, which is a bit more elaborate. Law enforcement was one of the big sticking points of the negotiations, a lot of conflict between us and the member states. So here you can see, basically, I tried to make it a bit shorter, AI systems that are used to assess the risk of a person to become a victim of a criminal offense. Polygraphs, to lie detectors, because I mean, some of us wanted even to forbid polygraphs, but they are already used even long before AI was even in the cards. So, okay, at least we make it high risk, because it's very weird that an AI system can predict whether or not you're telling the truth, but still. Then there is AI systems to evaluate the reliability of evidence, the one of to assess the risk for a natural person to offend or reoffend, but with a caveat, not only based on profiling, but based on objective facts. Because if it's only based on profiling, we will see later, it's actually a forbidden practice, which is predictive policing, also a long debated issue that in the very end, as Parliament, we managed to obtain as a prohibition. The fact of predicting, of an AI system predicting on the basis of the history of a person, whether that person might commit a crime in the future. This for us is like, a minority report, dystopic use case that we never want to allow in the Union. So we only allow it when it's related to an objective fact, when there is reliable evidence, so based on solid elements. And then profiling in the course of detection investigation, but not to predict a crime. So of course, we need to really navigate with a little bit of nuance, because it's very, very sensitive how we interpret each word of this text. Okay, moving on. This is really the prohibited practices. You might already know these are mainly subliminal techniques, exploitation of vulnerabilities, social scoring, the Chinese use of AI to score people based on facts that are not related to the context. So you are scoring them for example, I get points for, I don't know, tax relief because I collect my waste correctly, or I go see my parents regularly, or I am nice to people on social media, meaning the massive collection of personal data on me to give me points based on what I do. So massive control of a person. So this is not allowed in Europe. Then we come to predictive policing, which I was explaining a bit earlier. So the fact of predicting whether a person will commit a crime in the absence of an objective and very verifiable fact. Then another very interesting one is biometric categorization. So the fact that an AI system is able to predict by just looking at biometric features whether a person is straight or gay or right-wing or left-wing, political opinions, sexual orientation, religion. Imagine an AI system that can predict whether a person is a Jew right now. I just let you imagine the consequences, especially not only if it is correct, which is it can already be bad per se, because it violates all sorts of privacy concepts and can be used for discrimination. But also imagine if it's not even correct, and it can lead to detrimental treatment of a person. In this same area, we see also the prohibition of emotion recognition, which in the regulation you find only prohibited at the workplace and in educational settings. Unfortunately, this was a compromise that we had to accept, so it will still be allowed in law enforcement and immigration areas. And then we have the untargeted scraping of the internet or CCTV footage to build facial databases, like Clearview was doing, just scraping everything of every picture of Facebook, without telling us, so that they can build databases to match faces with at a later stage. And then we have the big case of remote biometric identification, which is the most dangerous of all, because when it is used in real time, especially, it can lead to immediate effect. So maybe a person, we know that the police is looking for a person at a stadium. It has happened already several times. They see the faces, they scan the faces of all people who are there. the AI system matches those faces with existing databases, and they create matches and find maybe a potential suspect. Real time means that the police can intervene in real time and arrest the person on the spot. This can be really dangerous because it is proven that it doesn't function properly. It actually has led to many mistakes of innocent people sent to prisons because it functions less well, for example, for darker skin tones, for women. I actually witnessed myself at an airport security gate, this facial recognition system being used on a woman, on a Black woman, and the system was not recognizing her against her ID. So she blocked the whole queue because the system didn't function on her. And I heard her say, just like, my hair is just shorter. This is the only problem compared to the picture, but it just didn't work. And this is not even that surprising. So we should really be careful with those systems, and that is why only law enforcement will be able to use them, and only in these cases when there is a credible threat of terrorism, when they have to search for missing persons, or for the prosecution of a certain list of crimes that is in Annex 2. Previously, it was a list that contained 32 crimes. We reduced it to 16, to the most serious ones, and punishable with at least 4 years of detention. Previously was 3 years of detention. So the parliament really insisted until the very end to make these conditions much harder to achieve. It's worth mentioning that in this list of crimes, there is also crimes within the jurisdiction of the International Criminal Court. So this might be interesting for you. So in the prosecution of ICC related crimes, remote biometric identification can be used by law enforcement, provided there are some safeguards, which are the need for a judicial authorization, the limitation in geographic and temporal scope, the fact that the law enforcement authority needs to perform a fundamental rights impact assessment before deploying it. It has to notify the data protection authority of its own member state, and with the caveat that no decision producing legal effects on a person can be only based on this outcome, on this on the outcome of the facial recognition itself. These safeguards were long debated, and it was the result of a long fight of the parliament until the very end of that 3 endless days of final trilogue. So let me continue because we don't have much time. So I just wanted to mention a few more things that might be relevant for you. First of all, AI literacy. There is an Article 4, that basically obliges anyone who will have to deal with AI systems in a professional setting, both providers and deployers of high-risk use cases, with an obligation to have actually notions, basic notions, but still relevant notions of what an AI system is. And thanks to Professor Zurek already for giving us a broad overview, but also how it functions, because they will have to monitor even deployers, so even lawyers that are using an AI system for their everyday work, they have to monitor the operation of that AI system to check whether it is functioning properly. They have to be able to use it following the instructions of the providers. Sometimes these instructions are not exactly the instructions, I don't know, to build an IKEA library, you know. So it's not exactly something that everybody can do. It needs some notions that deserve specific attention. So it's very, very important that you take this into consideration. Then workplace use cases. As lawyers, practitioners, I'm not sure how you operate, but you might use tools within your law firm for task allocation, candidate screenings for job offers, or to promote a person, or even to fire a person. In these cases, you will fall within the AI Act in the workplace area. So you will still be a deployer, but for these use cases, so be careful how you use them. Of course, in all these cases, you will have to follow Article 26, which lists the obligations of deployers, which are basically, as I said, to perform human oversight, to monitor the functioning of the system, to cooperate with the provider and with the authorities in cases of problems, to inform the person that they are subject to an AI system. If you read them out, they are quite straightforward, and it's just one article, so we believe it's doable, you know, to comply with. Just one very quick thing at the end. I wanted to say that in the area of justice and law enforcement, the enforcement is not performed by the market surveillance authorities like the rest of the regulation, but because of the insistence of the parliament, it is mandated to either a data protection authority or an authority designated under the same conditions to designate the one in the law enforcement directive. So basically it means in those cases, it needs to be an independent authority. We are seeing right now the member states are already appointing which market surveillance authority they want as enforcer of the AI Act. Some of them have not realized that this paragraph is in, believe me, because in some cases they think they can just do with an agency that is appointed by the Prime Minister, like is the case in Italy, for example. This will not happen for justice and law enforcement, because in those cases it will still be the data protection authority, which is an independent authority. So I think I'm done. I'm sorry for being so long. I hope I didn't overdo too much.
No, thank you very much. You were nice on time, so that's perfect. Thank you very much. Yeah, that's very interesting because, of course, this is European Act, but it also gives inspiration, I think, for any kind of regulation that might happen. And of course, when it comes to Europe, you had the interests of different states, and of course, with the Rome Statute, you also have to consider those things. It's everybody has their own interests and perspective, I guess. So you need to combine everything. So I think it's also very interesting to know, maybe for the questions later, what were the difficulties, what were like how you can advise on, okay, if you need to find ways of doing guidelines or including certain things in a broader scope of regulation, what can we use, what can we do, pay attention to. So yeah, thank you very much, Laura. And now, if we can go to Mr. Massimo Sterpi, he's gonna introduce himself as well, and yeah, I think it's going to be very interesting also to have his perspective coming from a different bar association. So that's also something interesting to have.
Yes, with pleasure. Thank you. I will focus on a slightly different angle, and actually I will talk about actual use of AI by lawyers. There has been a lot of writing and discussion about use by civil lawyer, but actually much less about use by criminal lawyers. Why this? First of all, because a criminal lawyer, of course, forgive me if I'm not accurate, but tend to be less using written brief rather than civil lawyer or commercial lawyer that are basically involved in very long drafting efforts of contracts, of brief, of legal documents, whereas there is much more activity non in writing in the criminal lawyer activity. So, like investigation, like contacts with the public prosecutor, contact with the justice, contact with the witnesses. And then, of course, there is a part in writing, but it's not predominant. So, whereas the impact of AI has been, on the one hand, sort of overestimated, like something that was really deployable and substituting the activity of a commercial and civil lawyer overnight. On the other hand, there are other areas where actually AI is always more and more used without even being perceived as such. Here I will briefly touch upon 3 points. One is the use in the drafting of documents. The second one is in the collection and evaluation of evidence. And the third one is the use of AI by the courts, by the judges, which is very, very delicate. So on the one hand, clearly there are uses that we are very much accustomed with, like a use of AI or to make case law searches or precedent searches. We have been doing that for decades already. Before it was more based on a use of string of text, a bit Google style. Now the machine learning and the new algorithm have permitted not only more deep, let's say, more in-depth, let's say, excavation in databases and in precedents, but also a different form of output. Because whereas before the output was typically a link to a decision or to an article, now you can have outputs that are already pre-crunched as a text. However, that I would warn user not to be too much trustworthy on a decision transformed into readable text, because that effort done by a machine is not guaranteed at all, and certainly is also potentially extremely dangerous, because one thing is to rely on the decision, and you pick up the parts that you think relevant. One other thing is to use an elaborated version of one decision, or even a text that put together elements from different decisions, trying to connect them somehow. And always remember that while the output of artificial intelligence, especially of generative AI, always seem human, that's why is generative AI, not so much often it is accurate, meaning that while it looks perfectly reasonable, sometimes it's totally wrong. And that's a big trap. That's the latest lawyer trap, that in order to take a shortcut, and as it sounds so natural, it sounds so reasonable, it sounds so well in your own language and even in legal jargon, the temptation to take things and put that into your brief, into your memo, whatever, is very high. But actually, the reality is that you have to do the opposite. Whenever you see some content, actually you have to double check it. you have to consider your AI, let's say, algorithm, like a 12 to 13 years old child that is helping you to do some work. Maybe it takes something right, but also coincidentally, but it's very likely that there is something wrong. We made a higher effort and we tested the most performing, apparently, system on the market. And actually, this system tells you, okay, not only I give you the output, a readable text responding to your question, but I even put notes, and every part of the text is justified with a note where you can go and find where did I find this content. And then we read the output, and then we checked the notes. Many of the notes were completely wrong or didn't say what you pretended they said. So actually, that's even more misleading. You say, oh, there are the notes, so it's there, I can check. But then the thing is, sometimes when you think that you can check, you do not check, because that's the risk. So in legal writing, the research can be more profound, more in depth, but don't be too much, let's say, relying on outputs that you can cut and paste, because we are not there. Always remember that the machine is not reasoning, but is simulating reasoning, meaning that the only thing it can do is to find something already pre-existing that is as close as possible to what you requested, and to make it sound a response made by a human. So it's an entire process of mimicry or mimesis, but it's not a clever answer. Is an answer in disguise, is not a real answer. The other thing that you have to be careful when using AI in the drafting is also that, especially as criminal lawyer, you all deal with extremely delicate information that if they were leaked by accident, could have disastrous consequences on your strategy of defense, or even on the on the outcome of the proceeding of your client. The other thing that you have to remember is that, especially if you use free of charge system that you find online, because basically all big systems have a version that is available for free online. The free version do not guarantee at all that they are not going to reuse your information for training their AI. So your information becomes part of their inventory, meaning that imagine that you are working on your defense, and coincidentally, the public prosecutor of the judge make a similar search, and the output may include the information that you have put into, which coincidentally are very, let's say, accurate, very much relevant for the search. And we have example not from criminal law, but example like this young employee of Samsung or LG that used ChatGPT to summarize and create a memo out of this meeting about the newest products that, let's say, LG was going to be launching in the next months. And then a young guy asked a question to ChatGPT, what will be the new product that will be launched by LG in the next 6 months? And LG just restituted the memo as the answer. The memo was certainly the most relevant answer. Imagine if that happened with your own brief, defensive brief. So, or images, or text, or other kind of textual evidence, or a transcript of witnesses. So you can use, in order to reduce this risk, you can use the paid for licenses on these AI platforms. And normally, this kind of platform permit you to avoid that any input from your side will be taken and used by the system in the future. So your content becomes siloed, which is good. Same apply for automated translations, because same as I described, if you do not have the paid for licenses for DeepL or this automated translation tool, your content can become the patrimony of the translator. It can be restituted in ways that you wouldn't allow and wouldn't permit. So this is about writing, legal writing. Then there is, of course, the use of AI to gather and evaluate evidence. Where AI can be very relevant is to find information about somebody. Now, with AI-powered search engines, you can collect many more information about subjects that are relevant to your investigation, potential witnesses, or people in an area, people in the field, people that was living in a certain area. You can go in depth into these searches like never before. So that can be very useful. And then without you perceiving that, there might be tools that are powered by AI, which an incredible higher accuracy than before. One example is DNA testing. With AI-powered system, now it is possible to identify or exclude identification of someone based on minuscule traces of DNA, whereas still a few years ago, in order to conduct an accurate test on DNA, you needed a relatively significant quantity. Same applies to blood, the same applies to other organic traces. So that's made possible by AI. You have other like microscopic examination. You have, for instance, a system that permit you to evaluate somehow if a painting is or not by a certain artist based on certain traces and patterns that can be found in the other paintings that certainly belong to the artist, and all these kinds of things. So evidence gathering and collection of information about someone can be significantly improved. But that's not something that you need to know more than just buying the tool, which is AI powered. It's like when you buy a car, you don't need to know how the engine works. You simply turn the key and drive the car. The final aspect that I wanted to touch briefly upon is actually the use of AI by judges. This is, in criminal matters, in my opinion, particularly dangerous and delicate. We all know how much the personal interaction between the judge, the parties, the person under investigation, the witnesses, count in the final decision. If you filter everything through an AI, all the non-verbal communication get completely lost. And actually, decision will not so much be fact-based, but will tend to be much more statistic-based, which is a very dangerous form of injustice. Because not just because 20 people in similar condition were convicted means that I have to be convicted. Because maybe I have an alibi, maybe there are other reasons why I was not guilty, maybe there is an unknown, let's say, author of the crime, whatever. So turning the criminal system that has, by the way, the very civilized rule that in doubt, the person under investigation has to be acquitted, and turning that into a statistical system where even the judge will rely on the suggestion of an artificial intelligence, or even will ask a generative AI to help him to write a decision, cutting corners, taking what a machine based on statistical algorithm will decide to pick up. Sometimes something, maybe that certain information will be like considered relevant by the AI because it's mentioned 4 times in the paper. And maybe the one information that is only mentioned one and is very tiny is actually the decisive element for the decision in favor or against someone. So these kind of points cannot be delegated to an artificial intelligence. At this point, there is no much regulation, but we know already that some judges are using like generative AI in their own activity. Also because how can they be spotted? You know, actually there are AI detection tools that can tell you with an accuracy of 99.9% if a text has been written by a human or by a machine. Because machine, they look human, but actually a machine can understand that they are not human. But for the time being, where we are still in the infancy of AI, we may go through a period where judges, we are typically overwhelmed and have too much work to do. They can decide to start using that, and we will be the victim of this lack of accuracy. So a lot of opportunities, but for the time being, a lot of caution that has to be used. And I would conclude my brief overview by sharing with you a law of technology innovation that is proving right also in this case with the advent of a generative AI. New technologies tend to be overestimated in the short term and underestimated in the long term. Here, we are not breaching the rule. For 6 months, it's looked at, we are all going home and having nothing to do, and the new lawyer would have been machine. That has not proved to be true, and even when we try to delegate too much to this machine, we risk to create disaster. And by the way, we are responsible for those disasters because we are the one that decide to delegate this activity to a machine rather than doing that ourselves. But in the long run, we cannot underestimate this technology. We must understand, we must test them, we must hear to others that tried them, and to be careful, and then to be more confident, and knowing that this is a tool that can permit also to work at a higher quality level. Imagine when you already written a text and then you ask the machine to debug from typos or to review the translation that you have already done. So there are certain many opportunities, but it's not magic. It's just a machine, and we're still human. Thank you.
Thank you very much, Massimo. That's very useful, and it's interesting indeed because it's very often we have certain practitioners looking at a different perspective. So you have, for example, trade law or labor law, and with criminal law, you look at things in a different way. Other things are not more important, but more looked at than in other fields. So thank you very much for that. And that brings me to Paul, because now we're talking a lot about Europe and or how we know it around here. But of course, in Canada, maybe you have other ways of dealing with certain things, especially with your field. It's very specific to technology and law. So yeah, we're very interested in knowing how you've experienced it so far, and what you know about this.
Thank you, Eden. Thanks for inviting me. My name is Paul Gagnon. I'm a partner at a firm called BCF. that has offices in Montreal, Quebec, and Paris as well. My practice is almost exclusively based in working in the field of AI. I was lucky enough to be exposed to the field around 2017 when it really started emerging. I was working for a startup back then that had received quite a bit of funding called Element AI, a startup that we ended up selling to a big American tech company, as those things go. I prepared a quick presentation to kind of go through some different thoughts, and I think one key aspect to start with is what I do day to day. I help a range of clients. Part of those clients are startups and emerging companies that are building AI products, and so we coach them on product design, product strategy, but also on commercial strategy, how to sell into the clients that they're building. And on the other end of the spectrum, I work with bigger companies that are trying to wrap their heads around how do we adopt AI? What are the best practices in doing so? How do we contract for AI? So really, a lot of the canvas that we worked with has been really well described by Laura, for example, with the EU AI Act. Just by way of background, in Canada, there is a bill being considered that would bring forward certain elements, the same kind of risk assessment. It's still being debated, so we're not clear on whether it'll exist or not in its current form. But that said, I think one starting point as lawyers is to understand that though technology can bring new questions, the law often has answers or beginnings of answers to these new questions. And so Quebec is an interesting place because it is a civil law jurisdiction in a common law world. And we do really much live at the intersection of both of these worlds. And so the civilist reflex to say something new is here, we need a new law, is often confronted to the more common law reflex of saying, wait a minute, what do we have that already exists that we can combine and adapt with these legal principles? And so in the absence of a clear law, we find ourselves more tying to existing practices, common law principles, and existing bodies of law that ideally, transcend the form of technology. And then where there are gaps, specific, legislation can come in and help clarify obligations, risk assessment processes, and all of that stuff. So with that quick word on legal theory, I'll jump right in to the presentation that I prepared. I'll skip, I think, through. I'll probably end up skipping through a number of the slides, given the quality of content that we had the benefit of. But without further ado, let's go with this. Can you all see me or just the slides?
Yeah, we can see the slides.
Okay, great. Okay, so what is AI? We had a really clear definition that was spoken to already. Echoing Massimo's points on the third bullet is really, we're seeing two things in the market. The first is there are companies and products that are really putting AI first. And that triggers, I think, a different conversation commercially than products that are slowly but surely integrating AI behind the scenes. So I very much echo Massimo's point on this, that there is a lot of AI behind the scenes that we don't necessarily are aware of. And so there should be more transparency and increased transparency. We're definitely seeing that more and more in the market, where the presence of all of these AI first solutions is creating more questions about, the other IT tools that could be using AI and what that means from a risk standpoint, from a data standpoint. But one thing that I really want to be clear on is that AI is not synonymous to automation. The image here is an interesting one. It's from the 18th century, where there was this machine is called, back then it was called the Mechanical Turk. And so it was this contraption that would play chess. And what people would think is, hey, this automaton is playing chess by itself. And so the audience that would see this device would be very, very mystified at the ability of this, automaton to play chess. But obviously, behind the scenes, as you see on this image, there was actually someone underneath the covers behind in that cupboard, actually, activating the automaton. And I think that this is something that we see happening in AI. Companies that are building AI are doing so or promoting it, for a number of marketing related reasons. And behind the scenes, sometimes it's a bit more manual than we would expect, including, for example, Amazon's automated checkout stores. So this was announced with a lot of fanfare where, you could walk in and walk out of a store and your account would be billed automatically. Turns out this was powered by over 1,000 data labeling workers working in real time in India. Likewise, some delivery robots that, we see as some of the future of automation and robotics were actually remote controlled and powered by teams in Colombia. So really, those examples and the allegory of the Mechanical Turk should be enough for the audience to take this away with them, is that AI systems are not synonymous with automation. They are IT systems that we deploy and tailor and customize. And in that decision, the person or the organization deploying it chooses to automate or not a certain level of decisions. So there are principles that emerge that help us kind of better understand what this means. One of them is a human in the loop. So this is where, for example, some key decisions can be made. All of the decisions described by Laura would be a great example. Some of these decisions should be reviewed by humans. This is the human in the loop. So again, to kind of break away from this automation, bringing in and factoring in the human is important, but it also assumes that these systems are explainable.
Sorry to interrupt, Paul. Sorry,
Yeah.
I think you're not sharing completely your screen. I think you're not in the diaporama. Thing.
Apologies.
That's all right.
Am I sharing it now?
Yes, but they're just still in the normal.
Okay.
Yeah, not.
What
in
about
the big...
this? Is this better? No.
Yeah, I think you have to. I don't know how to do this on PowerPoint. How do you click it to make it like a diaporama?
I did it on my end, but let me just try again.
Okay.
I'll probably just share the whole screen.
You're probably sharing a wrong window.
Let me see. Nothing like saying you're a tech lawyer, then not struggling with technology.
I think at the bottom right, you have like a next to the Zoom thingy. I think you should be able to. Am I saying this right?
What about this? Can you all see this? No.
Yeah, but then I guess we can just do one after the other.
Can you see this? Is this displaying on screen or no?
Yeah.
No.
Okay, perfect. Okay, great. So I guess all of this talk about the Mechanical Turk went to nothing because the slide wasn't showing. That's great. Okay, so here's so this is the image, the Mechanical Turk I was talking about. And to just recap, really, I was talking about human in the loop and why.
Sorry, it's still not visible. It's still not visible.
Still not visible. Okay.
Yeah. I think
All
you
right.
should choose the
Google
right
montage.
window for.
Is this showing?
Oh yeah, that's where.
All right, off we go. All right, we're off to the races now. Apologies, everyone. It's the interaction between Teams and Zoom. I think there must be some latent tensions there between the service providers. So this is the image that I was alluding to, the Mechanical Turk, that took the world by storm, but ultimately ended up being humans behind the scenes. And to bring back to humans in the loop, it requires a certain level of technical ability from these systems to explain why they're making a decision. So explainability in AI is actually a technical challenge that is still, kind of a frontier question, right? Understanding why recommendations or decisions are being made by an AI system, especially those that are trained on deep learning models, is extremely hard. And so this is where there could be a gap between what the legislation expects from organization and where the technical progress is there. But, it's an interesting example of push and pull. of technical capabilities between the legal system saying, well, if you're going to deploy, make it explainable. If you're going to deploy, put humans in the loop that can explain. If that's not technically feasible, then there should be increased research to make that work. And I definitely know of interesting companies in that space. So to go back to judges and if not judges, then governments using AI, the Canadian federal government adopted guidelines as early as 2019 and 2020 on automated decision making. And those are, I think, really an interesting point in time. One, it was quite early for a government to be taking a stance that clearly. And two, one of the things that these guidelines do is they say, well, if the state is going to be automating decisions, that automation can only grant and confirm rights that are available. Automation cannot be used to deprive any individuals of any rights that they would have. So basically here, we have this policy that says automation cannot deprive someone of a right. That has to be human reviewed. There has to be a human in the loop for this to happen. So we see this this principle, I think, is important to show that even when you are deploying AI, if you're going to kind of cross that line into automation, there are ways that you can bound your decisions. From a technical standpoint, the systems you're deploying, if you're not certain enough, or if the system's not reporting a high enough confidence in its answer, that could also mean that it's the right kind of parameter to bring in a human to review that decision. So as you can see, liability and managing these risks requires a lot of technical understanding. A lot of technical factors come into those decisions. So really, when people talk about AI governance, it's not just having a couple of people sit around a table and think about, oh, what are the risks? It's really proactively managing that risk, proactively designing those systems to anticipate this level of risk. And this is something that day in, day out, this is the kind of work that I'm the most passionate about. It's the kind of work I like doing the best. But beyond that, I think if everyone leaves with that notion that AI is not synonymous to automation, I think that'll be I'll be happy. And another comment on this is that this conceptual gap of assuming that it is automated, what it ultimately does is it limits our perception of agency and responsibility for the deployers of AI systems. And here's an example. A couple of years ago, Amazon was subject to media reports that it was using discriminatory hiring tools that were AI based. So it was basing its hiring practices on discriminatory AI. And so the response was basically, oh, thank you, everyone. We sprinted and caught this bad algorithm and tackled it to the ground. And now we locked it up and everything's fine now. And so there's this kind of notion that that it wasn't their fault, that, oh, okay, well, the system was discriminatory. Thanks, everyone. We're going to go back to the same discriminatory hiring practice, except it won't be automated this time. Thanks, everyone. So I think this interaction and this liability, I think is important to consider when you're making that leap to automation. You're taking a step away from the people that are deploying the systems. And so I think that's an important image to keep in mind. We did talk about AI. I'll go through this really, really quickly. Who recognizes this character? Quick show of hands virtually if you want to vote or not vote. A number of folks do. I'm seeing some smiles. Okay. So who recognizes this character with this image? More people will. And obviously we recognize Waldo. Okay. So you don't have to play Where's Waldo a ton of times as a human to understand the intent of the game. And to understand that what you're going to be exposed to is this bespectacled guy, kind of tall, wearing a striped sweater, and the goal will be to find it. Children understand this game. After one or two examples, they'll understand it and know it quite well. A computer vision algorithm, an AI system, would probably see this mess of pixels. It does not have any innate understanding of who Waldo is or isn't, or what the purpose is of this game, right? So though we can configure and put the parameters in place for an AI system to perform extremely well at Where's Waldo, it does not know who Waldo is, does not know that this would be a game, does not measure outcomes, does not understand that ultimately this is just a curiosity. So the question is, does that really count as intelligence? What it also points to is the fact that when you're working with these systems, it takes human intervention to label and to identify Waldo. Tomas earlier said, cat versus dog, Waldo, not Waldo. Really, in all of this data curation and data pipeline, there is a ton of human intervention. And to move to the, what we presented as the AI value chain, all of these different steps here on the slide go into the deployment of AI systems. So from data gathering, data cleaning, annotation, standardization, all of these data steps here in the beginning are actually super cumbersome and take a lot of resources, a lot of energy. And in that, as you can see, also there is bias that comes in and is introduced in that data labeling step. And all of these steps here, there is work done that can skew systems and selecting data, selecting models in the other step. Those are all human decisions as well, right? So a lot of work needs to go in here at all of these different steps along the way, so that at the end, when you're deploying, you're doing so confidently. You're doing so after experimentation, after understanding the limits of the system you're deploying. So really here, all of these steps go in. If we had more time, I'd love to, hone in on all of these different elements, but really keep in mind that we focus on the end product of systems and using them as is, but a lot goes into how they're conceived, deployed, trained, retrained. And lastly, even post-deployment, there's a phenomenon called data drift. So a model is good at moment zero, but as it gets exposed to more and more data, it drifts, its performance shifts, and sometimes in ways that's not anticipated. So don't see necessarily deployment of an AI product as only a zero moment decision. Deployment is ongoing, and you should constantly revert back and assess whether model performance is still optimal and retrain if necessary. We'll get into some of the commercial aspects of that a bit later, but just wanted to show a flashpoint of these different steps matter, and we're not using systems that are kind of out of the box, right? Especially not AI that's not Gen AI. Even Gen AI to some extent, to be honest. I think there's a lot of different techniques to make those more adaptable to your own context, your own organization. So lots of work that goes into this. And to quote, and then make an analogous quote from Bismarck, who had said, "If you like laws are like sausages. If you like laws, never see them made. If you like AI is like sausages, never see it made." So jokes aside, I think we can move to this quote. Key takeaway, obviously we've heard this before, all models are wrong, some are useful. Definitely true for AI. I think we shouldn't overstate the ability to make decisions or recommendations. And as Massimo pointed out, I think the image that treat AI systems as a 13, 14-year-old confident teenager that you're kind of poking and questioning, I think that's a good, that made me smile for sure. And then this is a quote that I probably say too many times a day, but even a broken clock is right twice a day. So meaning that ultimately even poor systems can sometimes make good decisions or provide good outcomes, but that's definitely not the case. And there's often more that goes behind the scenes. Wanted to speak a little bit about data considerations for AI. Again, I know we wanted to leave time for questions, but all of these steps ahead on how we use data, I think in popular culture, I think we're kind of now used to the fact that, data is abundant, data is everywhere. All of these giants are building off of so much data, and we live in this age where data is abundant. This is, for most companies in the world, fundamentally untrue. Finding appropriate data for use cases is quite difficult, and there are really important considerations that go into finding and licensing that data. So licensing is really acquiring the rights to use it in AI. And using an AI means different things depending on the steps, and there are different considerations based on how that's used. What happened is when So one of the partners at the firm that joined at the same time I did, he and I were colleagues at that AI startup, and we would constantly get questions from fundamental research teams and applied research teams and product teams, and we say, hey, we found this data, can we use it? And our answer back was always, well, what do you mean use? What do you want to use it for? And so that led us to write a paper that we called the Montreal Data License, that we co-authored with some profs in AI, including Joshua Benjo, who's a Turing Prize winner. And so our paper on the Montreal Data License, what we did was break down and offer a new taxonomy for what it means to use data. So basically, along those different steps of what you can and can't do with data, because what we would see in practice is a lot of data licenses that would say, use it for academic research, or use it for research, or use it for non-commercial purposes. And these intentions were never really clear, because academic in AI, academic research can take place in companies, and universities spin out IP in AI all the time. So what we found was that a lot of data licenses didn't really do a really appropriate job of communicating what was possible or not possible. So if you want further reading on data licenses and why they matter, I definitely recommend our paper on this. That is actually a bit dated now. We published that, I think we started working on it in 2018 and published 2019, but it's still relevant. And again, another point on data is when we're adopting AI, organizations rightly are concerned about what data gets reused by the service provider. And this is a really good question to have, but the context really matters. So if you're building, if you're using an AI tool to build cases and to analyze really fundamentally confidential or privileged information, obviously confidentiality is super important. But take the example of a cybersecurity tool. If you're subscribing to software for cybersecurity, you actually don't necessarily want that software to only see your data. You actually want that software to see everyone's data so that it becomes a more powerful tool. So basically, the considerations that a company or an individual has on whether a service provider should use or not use the data should be contextualized and really assessed on whether there's an advantage in pooling that data and having the vendor pool it and provide a solution for many, or if there's confidentiality concerns or competitive concerns that mean that it should be only offered to one. And again, obviously for AI and data, cybersecurity concerns are essential. So are data governance concerns. So there's a whole number of considerations in how organizations give access to data, making sure that permissions flow through, that all of these access controls are reflected in, for example, a Gen AI tool. So if a company's building a chatbot for its employees to access company information, well, ideally that chatbot shouldn't bypass and go, access HR files or other, files that people don't have access to. So really, data governance in AI adoption is essential. IP, I don't want to spend too much time on IP, but just know that there's an intense patenting activity in the field of AI. But ultimately, fine-tuning, deploying AI remains a very human experience, a human endeavor. So sometimes more fitted to trade secrets, sometimes less so than patents. Open source software, open data, essential to AI historically and still today. We see a number of these models being open sourced, accessible, usable. What we're seeing, though, is that 20, 30 years ago, open source software meant something specific, and it meant that people could use it without restrictions. What we're seeing today is a number of models and data is accessible, but not necessarily usable. So it's not necessarily open in the fundamental sense of, or the commonly accepted definitions of open source software. IP concerns, definitely, when you're working with IP or confidential information and AI is coming in and being trained on it, there are concerns there, including on just training on data and extracting the value from that data and IP and moving forward with trained models. Yeah, I'll skip these parts here. I'll skip this here. Yeah, again, a quick word on deploying AI products or even just adopting them in your organization. You have to build these mechanisms to make sure that you're monitoring all of the different issues that can arise. So this includes, when do we launch a product? When is something good enough from a performance standpoint to say, okay, we're willing to take this risk or to deploy this product or service that's AI based? And as organizations, ask yourself, who decides that? Um, it's a bit different than the traditional software field. So I think that's something to consider, especially with public facing products. Governance also requires addressing when to pull the plug. So if you're deploying, for example, a chatbot to the public that gives information about different legal services or different cases, you need to have a mechanism to report and understand when things aren't working well. And that has to go to somewhere in the organization that is technically savvy enough, legally savvy enough to understand whether something should be taken down or whether there should be additional money invested into making the tool better. So again, AI governance isn't just this kind of sterile, someone has to decide. It's really active and ongoing, especially on products that and deployments that are made accessible to the public. And then, yeah, I think LLM-based offerings, all this is, the arrival of ChatGPT and all of the competing solutions since then was really a watershed moment. It changed a lot of things, including the public's perception of AI, that now is really assuming it's only just Gen AI. But what we're seeing in most large language models, this is the LLM, not the master of laws. That's probably the LLM that most people are familiar here. But yeah, the large language models, they're accessible in different ways that have different advantages for organizations. Almost no vendor of these systems says that your output is unique. So these are probabilistic systems, right? They take your prompt and basically compute the most likely answer. But most vendors are saying, by the way, we're not guaranteeing that this output is unique. So for companies that are using these systems to build logos, trademarks, anything creative, images, videos, all of that stuff, there's something more that needs to get into it, right? And you cannot claim, or at least most of the copyright offices that have taken positions say that this output isn't enough to justify copyright protection. There needs to be more human elements, human creativity. And then likewise, like these terms and conditions have acceptable use policies, and acceptable use policies for most IT systems were pretty straightforward. Didn't say much except don't use these systems for illegal purposes, don't circumvent our technology, don't circumvent our protection measures and so forth. Acceptable use policies for LLMs are essential. They tell you for different use cases what can and can't be done, how it can be done, whether a human's required to review the output. So if you're working with technical teams in your organization or with vendors that are saying, oh, we built this on top of ChatGPT, and you'll get your own custom chatbot, or it's going to be this retrieval software built off of XYZ, keep in mind that you do have to double check on these acceptable use policies to make sure that it's aligned with what's provided and what's possible by these systems, because it can be a bit surprising. Massimo touched on this, on reuse of customer data, reuse of prompts. Don't assume even underpaid plans that what you're putting will remain confidential or not. It may even be reviewed by humans to make sure that it's compliant, even if it's not used for retraining the systems themselves. So there's a lot of nuance here, and it's important, to identify not just how you're going to use the systems, but to communicate that to every potential user and tell them, look, these are the acceptable guidelines for this system. This is how we're going to monitor different kinds of information. And EU AI Act, nothing to say here because we had a very detailed presentation from Lara. And again, I think the takeaways is, the context, as you saw, is very nuanced. It drives a lot of these decisions in legal risk management, commercial risk management. You need to find the right expertise at the right time for the right scope. And really, ultimately, there are amazing opportunities in using AI, but you definitely need to balance out, the potential issues in order to take advantage of them. So that's it. That's what I had prepared.
Thank you, Paul. Yeah, thank you very much. So I think, I don't know if anyone in the audience already has questions. I mean, the floor is open, of course. I already have some, but I mean, I'm more comfortable with the rest of the audience to share their questions first, if that's also okay with you. And by all means, just turn on the mic, and then ask your question. And if you're not comfortable, you can always write it down, and then I'll read it for you. So, yeah, go ahead. Okay, I don't think anyone has questions yet, so I'll go first with mine. And I think it's for it's good because I think we've touched point on the confidentiality issue quite a lot, and this is something that came very often in the discussion of our working group. So that's great that that was discussed, because indeed, I mean, you might want to write your brief or your request in a certain way, and sometimes you might include information that doesn't necessarily have the name of the person, but you can still recognize a certain situation by adding some of the information. So that's great that we had the views of different people from that perspective. Okay, we do have one question, so I'll go with Amir Ali. The question is, are there specific controls for the use of artificial intelligence in international crimes? Is there an international body? I know that, Massimo, there are some guidelines that are being created for the UAI. So yeah.
Yeah, sorry, your voice was coming and going, so I lost a piece of you. Yes, absolutely. With the OIA, we actually made a big effort to create, let's say, a list of principles, about 12 of them, that are intended to guide lawyers of any jurisdiction, of any operating in any field, to use AI. So it's a list of matters that does not come out of the blue. Actually, before doing that, we collected all other guidelines or like white papers that have been drafted around the world. The first of them in the States was actually in California, then there has been Florida, now many other bar are issuing some. There was one by criminal lawyers, European criminal lawyers. There were many, but actually each of them were very much linked to the law of a state, and you could understand that, for instance, the structure of billing, or in the advertisement rule relating to advertisement, and many other things. We tried, as we could count on a group of about 30 people from all around the world, to have a more internationally balanced approach, and that I think we succeeded. Our guidelines will be presented at the OIA main conference in Paris at the end of October, and and they will be translated officially in English, French, and Spanish, whereas most others are only available in English. So we hope that also would create a guidelines. Now we are working on another project, which is a standard, let's say, AI policy to be used within a law firm, which is more practical, less like high level principle, or more practical guidance about what to do, what not to do, etc. in your own daily practice.
Thank you, Massimo. Thank you. Yeah, because that comes to, so this question also comes to another one that I had for Laura, because in terms of negotiations, so here we're talking about, okay, there's a third body, for example, that would be able to regulate all the biases and ethical uses of AI. There are probably some advice, I guess, that you would have when it comes to find some compromise, find some ways of taking into consideration, the implication of the use of AI, of course, but also some people might have other fears than others. So how was it in terms of negotiating? Because UA Parliament, this is a lot of states, so maybe you have also an advice for this.
Okay, thanks for the question. I mean, conflict and trying to find compromises was the story of my life for these 2 full years, not only within Parliament, so within, among all the political groups across the spectrum, but also later on with the 2 main other institutions, so the Commission, who drafted the first proposal of the AI regulation, and our co-legislator, which is the council, so the representatives of 27 member states, and each of them had their own specificities and sensitivities. France was the most attentive to innovation, but also wanted the most powers for law enforcement. Hungary would never have accepted the mention of gender identity in any of the prohibitions or any other mention in the whole regulation. So you have a lot of this. The EPP wanted the companies to be able to do everything, and law enforcement to have the maximum control over citizens, whereas the liberals from Germany, for example, wanted companies to be free to do anything they would want to do ever. No boundary at all, but the state could not control in any way the citizens. So it was a very, very complicated puzzle. And well, you just need to listen and try to, with respect for every opinion, and try to come together because there is a common goal in the end. The common goal we had in our case was the approval of this regulation that for several reasons was important to have. For some it was a certain thing, for others it was another, but then it came together in one piece, and we really tried to find a balance between all those interests. I hope we did. I don't know, Mr. Draghi does not really agree with us, apparently. No, but I also, Hélène, if I may, I wanted to add something, because what Professor Sterpi also presented on, and what was also mentioned by Paul, were really very relevant. I mean, I didn't mention the whole area of generative AI, Gen AI, in my presentation, because I focused on really the most high risk related areas of the AI Act, but actually there is a lot to be said about how to interpret when an AI system does not have an intended purpose, but it's like a ChatGPT, like a system that is derived from a general purpose AI model. It can perform several tasks, and is used then. It's very accessible to anyone who wants, and so also by lawyers, by judges, in their everyday work. So what happens then? It's interpretable because it depends on what level of control they have and what level of intervention they have over the system. At the very minimum, if they use it for purposes that are within the high-risk use cases, they are deployers of a high-risk AI system. But let's also be careful, because if a provider, as Paul was saying, of an AI model says very clearly, my LLM cannot be used for this or that purpose, and you use it for that purpose, and then it hallucinates, as Professor Sterpi was saying, because it really happens very often, or is inaccurate, etc., then you're liable, and you can even to a certain extent of interpretation be considered a provider under the AI Act and have the most responsibilities. So really, really, really be careful in deploying those systems, in using them, even when they are super, super easy to use. It's actually even more dangerous, because we've heard why. So.
I think just to complete on that, like the EU AI Act shifts that burden, right, to users who use Gen AI systems or general purpose AI systems without that authorization. But just from a technical standpoint, it is absolutely impossible to meet any of those burdens and answer as though you were like if you're doing this, there is absolutely no way to comply with any of the obligations, most of the obligations.
Yeah.
So
and that's why you shouldn't do it.
Exactly. Yeah, no, I had a client ask me the question, okay, well, what about like, what would we try to use it? And I said, look, there's no way you'll access any of the information required to do it. So yeah, I think practically speaking, it's an interesting shift of burden that the EU AI Act accomplished.
Thank you very much for both your answers, and I think it replies to somehow the question of Mark Diamond, if I'm right, because his question was indeed, what is the difference between generative and non-generative AI, and can AI be compensating for biases in the way humans code the information that they are feeding into the system? So.
Maybe I can at least partially answer to that question. Maybe I'll start for the first part of the question. I mean, the difference between generative and non-generative AI. Non-generative AI, if you, of course, still speaking about the machine learning-based mechanisms, non-generative AI is just a kind of, you can imagine, kind of mechanism of classification, something which can differentiate a cat from dog, or any other pattern, whether the sound, text, or whatever, something which can you can have a number of patterns, and you just select put input and you select what this input means. For this is cat, this is dog, this is something else. Generative AI is a mechanism a little bit more complex, because this is a mechanism which when you put some input into it, and then on the basis of that input and previously trained on the basis of lots of data. For example, lots of text, like a whole Wikipedia or any other text, can predict what will be next after your input. So it puts, for example, a question to the system, and the system analyzes each word of the question, and take into consideration all the relations between questions and words in all the text it predicts next words. What will be next word, will be next word, will be next word, will be next word, and so on and so forth. And then we have generative, in the sense that it generates the next sequence of, let's say, words. Of course, it could be also picture, whatever, but it's simplest for us to explain with words. So this is something when we just trying to predict what will be next after the sequence of, let's say, question, or it's not necessarily must be question, but explaining of something, or write me something what I want to write me a brief of this very long description of a case, for example, and this is something like we can call it generative AI. So this is the difference. And the second part, can AI compensate for bias in the way humans code the information? In this sense, I really doubt, because similar to my previous speaker said, AI don't understand in the sense in the text in the way how we are doing, and don't reason in the sense that then there's something like a bias in the text. It just statistically repeats, let's say, words, for example, words. So there's nothing like compensating of bias in the. Of course, it can, maybe other words, it can compensate the bias in the sense that for example, if the data on basis of which the system is trained are correctly prepared and unbiased and so on and so forth. So in this sense, it can correct the bias, but it's impossible to have unbiased data because people are biased, people on the basis of which opinions are biased. Let's say the system is trained, they usually are biased, and that's why all the system are biased, and the bias is included in the data. It's in fact impossible to detect that bias because we don't know what we are looking for in such a data, and that's the reason why in ideal situation it could be possible to compensate bias, but in the real world it's impossible. Always the system repeats the bias which we have as humans. Humans, we create this data, so the data created by us are automatically biased. Also, even I can some personal impression. Also, even if we look at the judge's decision, there was a very famous paper written by Donald Katz and his colleagues from Stanford that they took a court decision from American courts. I don't remember which level of court it was, but that doesn't matter. And on the basis of the auxiliary parameters of the cases, I mean the date, the place, the geographical place, the names of judges, the political opinion of judge, for example, they create a mechanism which was predicting the decisions of judges, and such a mechanism has an accuracy about 70%. Without any point about the substance of a case in this data. It means how much people are probably that's why probably it was people just were biased by something. For example, I don't know, probably before the lunch they wanted to make quicker decision than when they are rested and not hungry, so or something like that. But this is something which suggests that our biases are very much into all our decisions are somehow biased. So it's very difficult to be analyzed.
Thanks, Thomas. Thank you.
Yeah, thank you, Thomas. And it brings me to the question of Marina, because I think it's a bit related as well. So, she's saying that human oversight is very important, but in the end, are there more implications? Are there more things that we need to consider? So yeah, how I don't know if it's more Thomas or maybe Paul.
Yeah, I think it really depends on the context, right? And I think the EU AI Act will tell you that the higher the risk, the more of these different governance-related obligations you have. So, but aside from that, like more formalistic, I guess, answer, deploying AI or using it is different. If your organization is deploying AI, there's a lot of thought that goes into testing and it's called red teaming. So basically, before something is launched, you're trying to measure whether it's providing sound output, whether it's providing appropriate solutions. But it's really just, I think one takeaway is that it's not one point in time. You need to do this kind of on an ongoing basis to make sure that that system remains stable, remains reliable as much as possible. And really, deploying AI is not just about saying, okay, well, we've identified the right models, we think that it'll solve this problem, and off you go. It's also about how is that interaction with humans being thought of, right? Like, will there be a human user supervising it? If not, then why not? And if so, then how are these kind of outcomes being measured? Is the company accepting, a certain threshold over which, well, the AI system's not confident enough for this answer, then it needs to go somewhere. So I think there's a lot of design that goes into this that means that ultimately, are there more implications? Yes, a ton more implications. Some of them technical, a lot of them organizational.
Thank you, Paul. Yeah, and it that brings me to the question, maybe more to Laura. Yeah, I'm sorry, I'm not going with the order of questions. I'm trying to go with the logic of the answers. So there are a lot of implications. There might be a lot more people who are using AI now at the ICC. So does that mean that at the end we need to amend or adjust, for example, the procedural law regulations, because of course now we have certain ways of saying if you want to do a video link, or yeah, the rules of the evidence that is very it's very much part of the day life of ICC practitioners. So is that something that we need to address? Okay, so now that a lot of people are using AI, it means that we need to adjust the current regulations, for example.
Well, I'm not familiar with it, so I don't know what's there and what isn't there. I mean, as long as there is something about, for example, automated decision making, that's already something. If there isn't even anything on that, then definitely yes. But that wouldn't necessarily cover, in my opinion, also Gen AI. So yeah, why not? But what I wanted also to say is about what Paul was saying. You used the word deploy in a way that I think is a bit different from what we intend in the AI Act, because in the AI Act, a deployer is a user of an AI system. That's why I was always talking about deployers, because I would not think that lawyers, practitioners develop themselves an AI system to use then internally for their everyday work, but rather they buy it or subscribe to a service, and that's why they have less obligations than a provider who is the one who actually builds it and places on the market, that has the bulk of responsibilities and has to comply with the requirements that also include, by the way, post-market monitoring, which is very important, because as you said, indeed, you cannot just rely on the fact that the day you market it, you're done with your job. You have to constantly be aware of what happens on the value chain, and also in that deployers, so users, are very helpful in flagging things up, as we anticipate in the AI Act, for example. But sorry, I cannot reply more about your question, Hélène, because I'm not an expert in international criminal law. So.
No, thank you. It's already helpful, because the thing is, I mean, I think what might also happen is that it serves as an inspiration also to adjust the current regulations that we have now at the ICC. So just to say, okay, what's the scope? What's the limit? What is already like a guideline that can be used, and can it be in the rules and evidence? Maybe, but it can also just be a normal guideline for all practitioners, for example. So yeah, thank you. And this question is more for Thomas, maybe. Ali Azim was asking, so won't AI further complicate the established pattern of recording or screen out evidence, which meant for ensuring a right to fair trial, for example? So is that something that, because, for example, you were saying, like a tank bus. So of course, when it comes to recognition of certain patterns, so is that going to be complicating the whole process?
I don't know if we can say that it's about the complication of a process, because of course, from one hand, we can say that it can even help in the sense that it allows for better analysis of the, for example, pictures. Distorted pictures by something, we can that was a tank. For example, if there is a suspicion that someone, a commander in the war, does not make a decision which hurt civilians, and for example, if we don't know whether he was his observation, or I don't know, from camera was showed that there was a tank or bus, for example. And so we can analyze using that and the recordings with the use of AI, trying to find whether it was possible to recognize this object as a tank, not as a bus, for example, something like this. So in this sense, it could be helpful. But of course, from the other hand, it also could be sometimes a problem in the sense that we can imagine that some bad people are trying to use generative AI in order to produce let's say, fake evidences. This is something because, of course, currently it's rather possible for most of the situation to differentiate between let's say real pictures and artificial generated pictures, at least to some level. But I think in the close future it will be impossible to distinguish them. So it will be quite possible that there'll be people can produce, let's say, a number of fake evidences for the and the mechanism of detection also probably would require a very sophisticated mechanisms, technical mechanism to detect whether there are fake or not fake evidences. For example, pictures or whatever. I don't know. This is videos, sounds, whatever. Because it's yeah. So this is we can see there's a kind of war in two sides. One of them trying to help lawyers to correctly recognize proofs and so on and so forth, and on the other hand, someone who wants to mislead them or something like that. So this is of course very difficult and complex thing. I think it's kind of unfinished war. Someone lies in the course. Sometimes someone tries to defend himself and he uses sometimes real evidence, sometimes not. I don't know. So this is something which we can both sides. I think both sides.
Thank you, Thomas. And maybe to finish with hoping that we still make it with the 5 minutes, the last question from Joy Humphrey. So how do you foresee the role of AI evolving in the legal profession over the next decade? So I think this is Paul and Massimo. Of course, we have some guidelines there. Yeah.
I'm so sorry. I can jump because I find a small advertisement. Two of my friends prepared a special document about that, a book about that. So I maybe I'll send a link to it's publicly available. So I can send you a link to it about the. So this is a kind of something you can look at. They examined a number of a few hundred of law firms around the world about discussion of potential use of AI. So this is something which could be interesting. But of course, other speakers. It was just.
Thank you, Dan.
Mm-hmm.
No, thanks for that. I think part of my role at BCF is also for the firm's own internal operations, and what we're seeing is all of our practices are so different. So the legal profession is not a monolith by any means, and so what we're seeing right now is so many different companies are reaching out and saying, oh, we have the tool that will change every single thing in your practice, and I find that that's an overreach, because all of our different practices, a litigation lawyer doesn't work like a commercial lawyer, and even within commercial lawyers, that's like such a different realm. So I think there's no one size fits all. I think, again, here the goal is like augmentation of roles, right? And finding where some of the mundane tasks that are being taken on, like how do we make sure that they kind of run in the background and keep space for the high value add tasks. I think fundamentally it keeps the role of the attorney as an advocate really central, right? It just means that it's even more important to better understand your client, even more important to build that strong relationship with them and that trust that goes behind it. Technology makes that, or can make that easier. I don't think it'll change the fundamental ability, for lawyers to provide advocacy, to provide advice, to be strategic about things. I think it just makes that job ideally a little less grueling for us, a little less painful.
Thank you very much. Okay, so we have 2 more minutes. I think we can, unless Massimo, of course, you have anything else you wanted to add about.
No, just a word on that. Clearly, my impression is that AI will be everywhere, but it will not be so disruptive as we expected. Like when I started, there was one computer in the law firm, and then there were many computers. Everyone had his own, and then mobile phone, and then databases. I spent the first 2 years of my career going through books to find precedents. Now you take the same request in a database, you take the same information out in 20 seconds. Clearly will be used to obtain more high-level information out of AI. There will be probably an improvement of the output because the AI can improve to, let's say, increase the quality of what you are producing. And certainly it will probably automatize, the most banal routine works, but that's inevitable. But that's not the end of the legal profession, maybe a legal profession of a higher level.
Thank you, Massimo. Yeah, thank you everyone for joining, for for your input. That was yeah, like Marina said, this was fantastic. It was really helpful, and because it is new, and it's at the same time not so new, and everybody has their yeah, we're a bit of sometimes you're afraid of using, not using, what you're doing, what you're not doing, and how we can do it. So you have a bit of already experience on, okay, where can I look, what can I do? And I definitely think that this is something that is going to be a lot more used probably at the ICC. So that's also nice to have a first maybe picture of AI in the legal world. So thank you everyone again. And I think we're, yeah, 6 o'clock sharp. So that's perfect. And I believe some of the information will be shared, like the PowerPoint. So if anyone has, of course, in need of more information, this will be shared. The link that Thomas shared is also in the chat thread. And the last thing is that we're supposed to have Mark Tabot, who's also an expert in criminal conflict, international conflict, and she was gonna give a recording to also give her input. So maybe we'll put that in place as a separate webinar and see, of course, how this can be tackled. So yeah, thank you everyone for joining, and I'm wishing you a very lovely evening then.
Thank you. Goodbye.
Thank you
Bye,
very much.
everyone.
Thank you very much.
Bye-bye.
Thank you.
Thank
Bye-bye.
you.
Thank you all. Bye bye.
Thank you.